Hello everyone, welcome to LexTalk World Talk Show. Today we have Mr. Gunaseelan Arokiasamy with us. Gunaseelan enrolled as an advocate with the Bar Council of Tamil Nadu on 28th of February 1980. As a trial lawyer, he had developed extensive life skills essential for a professional like listening to intuition, listening with empathy, non-verbal communication, articulation, and professional skills like drafting pleadings, collecting and mounting evidence for both oral and documentary in support of the pleadings, examination and cross of witnesses, researching various legal aspects of the subject matter of dispute, and developing a rapport with clients as well as judges in conducting trials like taking optimum advantage of the developing technology. Hey Gunaseelan, how are you?
I'm fine. Thank you. Nice meeting you.
Nice to meet you too, sir. To start with our chat, right, for our audience, I would like to ask questions and I would like you to give us brief insights on that so that we can enlighten ourselves. So please brief us about your journey as a legal professional so far now.
Well, as you said, I got enrolled as an advocate on 22/1980 in the Bar Council of Tamil Nadu. Soon after I got an enrollment, on the very same day, I have joined the offices of Mrs. D'Souza and Radhakrishnan, at that time a firm of solicitor, a firm of advocates, who were mainly concentrating on practicing on the original side. So when I joined, I was the youngest junior there. And client interaction, when my seniors meet the junior and the clients, I used to be there in their presence. And they had a vast array of clients in their fold: bankers, companies, and firms, individuals who are doing businesses, and various associations, trade associations. So most of them used to come for legal opinion and connecting cases. And almost virtually 8 or 9 nationalized banks were under a fold. I'm talking in the terms of 1980. And we used to file cases. So I was concentrating more on conducting cases in the lower courts as well as arguing before and appearing before the high courts. High Court of Madras. There's one big compound in our High Court of Madras where all the courts are housed. It was easy to practice in the district courts and in the subordinate courts, as well as to appear before the high courts on the civil side. My practice was totally confined to civil litigations. And there are 3 important things which I learned during my period. I was with them for about almost 8 years. So during these 8 years, I have learned how to interact with the client. And whenever a client comes, how to collect evidence in support of his case, both documentary as well as his version, assemble it together, then study the law on the subject matter of dispute. And that requires extensive research. Once you arrive at the position of law, so far as that set of facts are concerned, then you assemble the facts once again to suit the legal requirements so that you'll be able to convince the court, look, this is a case, fit case, and this is a case worthy of being tried, and of course, obtaining a judgment. Back in 1980, up till, say, even up to 1988, we did not have the same technology that was available as on date. So our legal research or looking into the subject matter of dispute, so far as the legal aspects are concerned, was mostly confined to reading textbooks on the subject, law publications, and the law journals. Fortunately, we had at that time the All India Reporter. They used to have 5 years volumes, 10 years volumes, and then every annual volume, every year, every month, they used to send the volumes. They used to dedicate a few pages where they used to refer to judgments of the Supreme Court or of different high courts, which were relied upon in another judgment or which was dissented by the Supreme Court or relied upon or deferred from. So that way, it was a very, very interesting but hard job to study the legal aspects of a case particularly from the point of view of judgments. Now, there are three important things which I learned during this stage of my career. That is, one, assembling of facts, drafting a pleading, and presentation of the evidence before the court, and to convince the court. All the long retaining the trust of the client. And one important thing flowing out of this was the standards which you maintain in your practice, particularly the ethical aspects of it, the duty towards the client and the duty towards the court, and the role of a professional as an advocate, the standards which you have to adopt and to inculcate in your practice. These are very precious lessons which I learned during those periods. Then, of course, a time came in 88 or so when my seniors themselves urged that we have to get more exposure to the corporate side of practice. Therefore, I joined King and Partridge, another leading firm of solicitors, as a senior associate. And I was there for about 2 years, where I got exposed to the corporate style of functioning of a law firm. Then by 1990, I thought it's time that I have learned the tricks of the trade, or how you call it, or sufficient enough, confident enough to start my own practice. Since then, I'm continuing to practice even till this day as a trial advocate. I have concentrated in the area of trial advocacy because that is where I was tuned to, and it was a really, really satisfying job. So I continue to be a trial advocate, and I am still practicing on my feet in the court, but for this pandemic period, where of course virtual hearings had gone into place. The growth of technology is tremendous. What was available for us when we started our career way back in 1980, and I've seen the form of CDs, the law journals and law reports coming out in CDs, then in what we call floppies. Now we get pen drives and whatnot. So, and the search engines now available, the various blogs and the blogs in the internet, the IoT of things, that's how we call it now. Now they are providing us with so innumerable resources where we can do our legal research, which was not available to us at that point of time. Necessarily, so as we continue to practice from 1990 till this day, I have also adapted myself to this development of technology and started utilizing it to the optimum in my legal research work, as well as in conducting the cases. So my professional journey was quite satisfying, and it was enlightening. And the way the things are moving ahead, I'm going to see a lot of changes. I've seen a lot of changes, and the future ahead is so very bright for this profession. And I think I've covered almost like how I've crossed in this area of profession. Okay.
That's so inspiring. Your entire life is very inspiring. And yes, I must say all the young budding lawyers who all are listening to us right now will be inspired out of your entire journey. So now moving ahead with my second question to you, Mr. Gunaseelan. What I would like to know is, please brief us about your most memorable case or cases, whatever you want, and what are the key takeaways from there for all of us?
Yes, it's a good question, actually. You see, there are three important cases which I would say are milestones in my career. The first and foremost is the case where I was myself a litigant. The first case which I filed after I passed out of law was with one of my close friends, and he also happens to be a very senior member of the bar in the Supreme Court today, senior counsel. Back in the good old days, in our law colleges, we don't have, like we had the moot courts, but not so as what you call now it's happening, but there are a few moot courts. I had the benefit of being a member of a moot court team, and along with Mr. Arvind Dattar, who by now has become a jurist by himself. We were teammates together, and we went all the way up to Chandigarh to participate in a moot court competition. And that was very interesting. Like, of course, the Delhi team won, but we got the consolation prize also. So at that time, after we returned from Chandigarh, back to Chennai Law College, when we submitted our TA and A bills, the college didn't pay us. And by the time we were in the final year of our law college, so we are waiting for our results to be declared and enrollment to be over with. Then Arvind Dattar and myself joined immediately and filed a suit against the Director of Legal Studies for repayment. That case I will never forget, because that is the first case we filed. And of course, obviously we won. And then the director came forward and settled the matter. In many of his books or many of his memories, Mr. Arvind Dattar also would have recollected this event, because as one of the most important cases in his life. That is the case which we ourselves fight for ourselves. Now, the second important case which I would like to tell you is about a property dispute. Now, this is a dispute that originated in the year 1980 between, you see, the purchasers of a property who are all teachers and government servants who formed themselves into a group, about 18 people or 19 people or so. And they purchased 20 plots of land from certain individuals. It's actually a very senior number. What happened is, after purchase of the property and after obtaining patta and all that, after getting it regularized from the statutory authorities for the building of layout and all that, a few of the co-owners of the certain heirs, legal heirs of the persons who sold the property to my clients, they said, look, we are entitled for a partition, and they filed a suit for partition, claiming right over the property. Imagine 18 of these purchases, along with the vendors, were facing litigation from the legal heirs, claiming a right in the share of the property. And that litigation went on for about, initially it was because of the pecuniary jurisdiction, it was in the High Court. Subsequently, it got transferred to the Subordinate Courts, and the trial went on for 15 years. 18 people, 6 plaintiffs, 19 defendants, multiplied into 22 plaintiffs and about 43 defendants, with each legal person dying and their legal has been brought on record. So it went on for about 15 years. Ultimately, we saw the judgment in our favor after a trial, full-fledged trial. Then they went on appeal, and the appeal, it took another, another about 8 years or so, almost about 25 years. By the time the appellate court judgment came, I had completed 26 years after taking that case. So imagine for 26 years, if you have to conduct the litigation and to retain the trust of the client, what helped me most was the professional ethics which I have learned in the initial days. So that is what I would submit to others also. That these are all so many important factors in trial advocacy. Conducting a trial is not merely filing a case and then going and examining the witnesses and all that. It is more a task of managing a case. Managing a case not for a period of 1 or 2 years or 3 years, but over decades. So that's an immense case that taught me a lot of lessons. And I'm happy about that case. And the third important case I would like to say is, again, this matter went up to the Supreme Court and came back in the interlocutory stage itself and all that. But this, again, is a case where I have seen the joint family, which were the purchasers, who later on developed into a big commercial complex. the personal toll it took on the clients. I can see that, I can visibly see that. And I had felt that were cases where for the first time the Madras High Court had allowed a forensic expert from Bombay to examine the source because allegations of forgery and fabrication of documents were involved in the case. For the first time in the history of the Madras High Court, the records room, which used to be normally a place that is kept under lock and under the control of the Madras High Court, the clients were given access to and the advocates were given access to. We sat there for more than 1 full week photographing each and every signature of the document. At those times, remember, the Madras High Court, or for that matter, any other high court for that matter, did not have these electronic gadgets where they can record the documents or store the documents. And every document, whenever you apply for a Xerox copy or such a Xerox copy of the document, it had to be photographed and given it to you. So the dark room in the Madras High Court was a big hall. So that really, really exposed me to the advantages which we are all enjoying now, what we had. So that's a landmark case in the sense like, yes, for the first time, the access to the dark rooms of Madras High Court was given to Salon records. So that case I would really remember. And lately, of course, one of the cases that made sensation in the newspapers and all that was a case where a school correspondent was prosecuted criminally for the death of a school child who fell from the bottom of the school bus in which was traveling to a home. And the Madras High Court at that point of time, suo motu, took up that as a public interest litigation, issued notices, the result of which, the end result of which, of course, obviously I got a bail from my client and he came out of it. But new regulation was framed in the state of Tamil Nadu insofar as the school and college buses are concerned. The test, how the bus should be built, how many persons should be there, and rigorous, what we call, regulations were made, not only for adherence by the schools, but also by the road transport authorities. So that's another case which I would remember. And that happened to be in the 125th year of the Madras High Court. So even in the Madras High Court directories, they refer it as a landmark judgment for the High Courts. So these are all the memorable moments of the case. Yes.
Thank you so much. Thank you so much for sharing your most memorable cases with us, Mr. Gunaseelan. However, I'm sure that you have many more in your bag, right? But yes, the time is of the essence and we need to move ahead with that. So now we have heard from you like about your past career, like about what have you done, your memorable cases and all. Now, I would like to know about the present and coming future, right? So for that, I have a question for you, which is, how do you look at arbitration and mediation in 2021 and how it's going to change 5 years down the line?
Yes, that's again another very interesting question. See, arbitration in India has grown by leaps and bounds. I think the New York Convention in 1958 started the whole thing. But the first Arbitration Act came in India in the year 1940. Then it went on an amendment in the year 2016. And again now in 2018, now in 2021 also there is an amendment. Arbitration as an alternate is the most viable option for easy access to justice, because it is in the hands of the parties to choose the arbitrator. And a time-bound disposal of the dispute. And therefore, arbitration has now become a very structured process. The one thing I would like to note is, despite all this, of course, with expanding trade and with expanding commercial activities, arbitration is most preferred by many of the business community. And the in-house counsels also prefer because there is a certainty in these proceedings. And there is a certain definite outcome on that. The one thing I would observe for the year 2021 ahead, see, we have to see the arbitration as a process had undergone huge development after the Amendment Acts and with the pandemic. So we must thank the pandemic for that. Because what was used to be otherwise physical forum where arbitrators meet and the parties meet and discuss, this pandemic brought the virtual hearing into force. This virtual hearing not only had a dynamic impact on the court system also, but also in the arbitral proceedings. So formally, when parties have to come from abroad or parties have to come from different zones and across miles, they have to travel and come across to have a sitting in the arbitral proceeding. Now that has not been made easy. Equally, the one drawback which I see right now is it's again an adversarial system of dispensation of justice. In the courts, the judge decides. In the arbitral proceedings, the arbitrator decides. With one modification, now the arbitration process also allows the mediation at a certain point of level if both parties agree. So what is now is the prevailing rule is arbitration, mediation, arbitration. Or it might even go like this: mediation, arbitration, again mediation. So these are the things. But I could see the Supreme Court has contributed a lot to the development of arbitration by releasing the clutch the courts had over the arbitral process. What happens is many of the originally, as I used to see it and as I've seen it, the interlocutory orders, the interim orders that were passed by the arbitral tribunal were challenged before the High Court. And once it is challenged, the arbitral proceedings come to a halt, and then it might even continue. But then you see the period gets prolonged. Now there is a curb on period of arbitration, so you have to come to the court. But if the courts release their grip over the arbitral proceedings and confines itself to wait for the outcome of arbitral proceedings before it intervenes, then I think it could be much speeded up. Another aspect of these arbitral proceedings are this. You see, we lawyers are now, with the growing trade, multilateral contracts are coming into existence with varieties of parties from various zones across various projects. So for one infrastructure project, it might require 7-8 contracts with different parties. So yeah, now we'll have to get over this cut and paste system in having an arbitration clause and innovatively approach this and find a solution. So, but this is a developing field. Now coming to mediation. Mediation is at a crossroads so far as India is concerned. Mediation got a big push in the Pound Global Conference, and thereafter it has really taken off. Maybe in our Indian jurisprudence is yet to find a place, but it is taken off as a alternate dispute resolution process. But then here the difference is, it is not the judge, it is unlike our courts where the judges decide, unlike arbitration where the arbitrator decides, here the parties decide. So it is only the mediator plays a facilitative role or a collaborative role, at times an evaluative role, so that the parties can, it enables the parties to come to a negotiated settlement. Now, one distinct advantage in this process is, of course, most of the disputes, emotions of the parties play a vital role. Those emotions have no place in law, right? It is a question of right or wrong. That is what the courts are concerned with. Even in arbitral proceedings, the terms of the contract, parties are right or parties are wrong. That is the point. But here in mediation, the emotion of the parties are taken into consideration, and the emotions are slowly ebbed out of the scenario by focusing on the interest of the parties, where the parties themselves will see that, oh yeah, let's find this is a workable solution. Come, let us come to an agreement on that. That is a negotiated settlement. The crossroad is this. After the Singapore Convention, that Singapore Convention is a big boom for mediation. So far as India is also concerned. But then it confines itself only to disputes that are commercial in nature. And two, it is related only to settlement arrived at between the parties outside the legal forum. So it is institutional mediation and a negotiated settlement that became enforceable under the Singapore Convention. What necessarily means would be, in India, even though India was a signatory to the International Convention, we have not come out with a mediation law as a whole. Mediation in India is largely developed by, thanks to MCPC, through the court-annexed mediations, where the parties are forced to go into mediation pending a dispute. And then, of course, the mediation is brought into force. But then the problem is the parties are compelled to go in for mediation in the court-annexed process. But mediation should be a voluntary process where the parties must choose, is we will negotiate and settle the differences. Ultimately, what happens is, in the absence of law, today mediations are done in India, private mediations, other than court-annexed mediations, are done under the ambit of Section 74 of the Arbitration and Conciliation Act, where the parties enter into the question is become enforceability. Even in respect of mediations, which are international in character, commercial in character, now when it comes to enforcement, in the absence of a legislation on mediation, it's very difficult. So the enforceability is again a big issue in mediation. So what I foresee for the future is, there is a tremendous requirement for infrastructure being created with support of a legislative instrument for bringing effectively this mediation as a system of dispute resolution mechanism. The problem is this: it will not be an alternate dispute resolution mechanism. It cannot be. Alternate is alternate to court jurisprudence. It's an alternate to adversarial system of jurisprudence. Courts, we have adversarial jurisprudence system. In arbitration, again, it is adversarial, one pitted against the other to determine what is right and wrong. Whereas mediation is collaborative. It is totally a different one. And here, when the parties break, then what would they do? Under the existing system, again, they will come before the court because a negotiated settlement is deemed to be an award under the Arbitration Act. Therefore, you enforce it through the court after the elapse of the statutory period. But then it again can be set aside by a court under Section 34. See, that is why I said mediation is at a crossroads. So unless the legislature deems it fit and brings about a legislation on mediation, giving mediation its due place in the dispute resolution process. Yes, we have a long way to go in mediation, but we are at the fringes. I mean, we are at the beginning. Compared to the world countries, we are yet to go ahead. But given this situation, scenario, with the growing international trade, with so much of conflicts going on, I think any dispute, even to reduce the docket explosion in the courts or to bring about a dynamic change in the arbitral process, I think mediation must be made as a primary dispute resolution process. So any conflict, before it escalates into a dispute and takes its vent through either court proceedings or through arbitration, the whole thing could be at the seed level itself, at the entry level itself, be knocked out. many of disputes, many of conflicts, before even it takes the form of a litigation or it goes into arbitration, could be what you call vetted through this process of mediation. So I would rather say, I've come from 40 years, I can say with confidence, that mediation must be the primary dispute resolution mechanism, should not be clubbed along with alternate dispute resolution mechanisms. I hope and I pray that this new legislation which you're expecting, Supreme Court has contributed enormously to the growth of mediation. But for the Supreme Court, the impetus would not have been there for this mediation process. The consecutive Chief Justices and the MCPC and the recent judgment also is even negotiated settlement outside the four corners of court. When it is brought into a litigation, I think the parties are entitled for refund of court fees. That's to the extent Supreme Court has come on to say. So it need not necessarily be a negotiated settlement agreement in a pending litigation. Should only go through the court annexed litigation centers. No. Even a private negotiated settlement, the parties are entitled to have the benefit of court fees back to them. So by and large, yes, the future lies not in litigations or where the dockets are exploding. I mean, it can't be contained. I mean, like how many cases can the court system handle? Yeah, we should give credit to the Union government as well as the state government for developing the infrastructure in creating more courts, providing access to justice. But still, arbitration apart, I think the future lies in mediation, initially in all commercial cases, and then of course arbitration. So this is where we can bring about a dynamic change to the dispute resolution mechanism. I think I have expressed what I have to say about arbitration and mediation. In my view, see, I have seen this happening and I can see where it is leading to. So yeah, it's nice to share my thoughts with you on that. Good.
Thank you. Thank you so much, Mr. Gunaseelan, for sharing such great insights with us. And yes, of course, we look forward to having a chat with you again in the future on some other trending topics in the international legal industry.
Yeah, welcome. It'll be very nice. I'd be glad to do that.
Pleasures are all ours. Thank you so much for your great insights, Mr. Gunaseelan. And for our viewers, if you like this chat with Mr. Gunaseelan, please like and share this video and also subscribe to Clickaway Creators YouTube channel to appreciate what we do and have more coming from industry leaders. This is Ashish for LexTalk World signing off.